Good morning. Welcome to this Your Compliance Queries session, the session where you get to ask your queries of the SRA. Now, ahead of this event, we asked people, solicitors, to vote on what topics they would like covered in this session. And there were two clear outright winners, and that was client confidentiality and also dealing with conflicts of interests. So those are the first two topics we're going to be covering. We also had interest in covering reporting obligations. When do you need to report things to us? So we'll also be talking about that. And if we have time, we may cover a bit around use of social media, but we did also get to cover that 2 weeks ago at our physical event in Birmingham at the ICC. We had loads of questions there. In fact, so many questions, it filled the whole session. And this session will work way better if we get questions from you. So the way to do that is you click on the link below this video, submit your questions. It's nice to know your name, but you can do it anonymously as well. And we'll try and get through as many as possible. As I say, we'll prioritise the questions that are on the topics we're focusing on. So just a reminder, we're going to be talking about confidentiality first, then conflicts of interest, and then your reporting obligations. So please prioritise questions on that. But if you have other questions, we can try and wrap those up at the end or as we go along. So that's how it's going to work. I'm joined by three solicitors from the SRA who have lots of experience both in private practice and in-house. We've got Keisha, who's from our general counsel team, and then we've got Justine and Sarah, who are from our ethics team. So we're going to be taking each topic at a time, and how this is going to work is we're going to do a short introduction around that topic just to set the scene, and then we're going to get our teeth into answering some of those questions. So do get those questions in now. But first, we're going to go to Sarah, who's going to talk to us about the topic of confidentiality. So over to you, Sarah.
Thank you. Before we go into the topic of confidentiality, I thought I would introduce the team, the ethics team. We're a very small team. There's only 20, including full and part-time advisors. We provide guidance by correspondence. Last year we had over 4,000 pieces of guidance that we responded to, including urgents at short notice, together with the telephones, and we had over 20,000 telephone calls to our helpline where we helped the profession and those that work within law firms. Now, my topic is about confidentiality, and in the code you will find it in both the firm's code and the individual solicitor's code at paragraph 6.3. And that specifically says you're required to keep the affairs of clients confidential unless it's a matter of law or the client consents. And that's in a nutshell what that paragraph says. Yes, thank you. One of the difficulties is knowing when you feel you want to breach confidentiality or when you shouldn't take any steps and you would be breaching confidentiality. And with my experience on the helpline myself, we receive frequent questions, and the questions are where solicitors, can they disclose this information which has come to their attention during the course of the retainer. And one of the common questions is where they're acting for personal representatives in the administration of the estate, and it comes to the solicitor's attention that the deceased received overpayment of benefits when they have a duty, and they ask, do we have a duty to tell the DWP, Department of Work and Pensions? They cannot disclose this to the DWP without the consent of their client, and their client will be the personal representatives. Even though the solicitor may think that they have a responsibility personally to inform the DWP, they have no professional duty to do so. And this usually causes solicitors quite angst to think about that. So that's quite a common question, where they feel they need to tell a third party, but they really have no professional obligation to do so. The next one is a very difficult situation, and it can be quite daunting for them, where the client has threatened suicide. The solicitor will wrestle with their conscience and ask what can they do, and they frequently phone us where they want to talk it through, and they probably have already made a decision themselves, but they want that reassurance. And it's helpful that we cover this in the guidance note on our website. And they're worried about breaching confidentiality if they pass on their concerns to, say, a family member or a doctor or the police. If they are unable, or the client does not give consent, they may disclose their concern under exceptional circumstances, justifying the reason for the breach from the conduct point of view. And of course, you know, we would take that into consideration if a complaint was made to us. And to mitigate the breach, they must believe that the client's threat is genuine and satisfied that they have no other way to deal with it. And we would say not to disclose anything more than is necessary to protect the client, keeping a full note of the circumstances and the factors taken into account so they can justify the reason if called upon to do so. So keep a file note, and it is very, very difficult in those situations knowing what to do. Another common situation, and I think this comes up quite a lot, is when solicitors move firms. And they move, and you know, they may join as another fee earner or in a partner, you know, in a manager's role, owner of the firm. And in the case, you know, they still have a duty of confidentiality to their old clients and cannot pass on information, including the client's name, to the new firm. If the new firm is acting against a client or a former client of the old firm, the fee earner cannot personally act. If the interests of the clients are not adverse, new firm has to ensure confidentiality of the other firm's client is protected, and where there is adverse information, safeguards would be needed. And those are the really three common ones that we have that come in during correspondence and on the helpline. Thank you, Ben.
Thank you, Sarah, and apologies, I'm being told my sound wasn't coming through on my original question. Some may see that as a benefit, but actually probably chairing this session, it is going to help if you can hear me. So thank you, Sarah, for talking through the most common queries you get. We've got a couple of queries coming on this, but do send in more questions on this issue, either confidentiality or conflict of interest. And I suppose I wanted to come, and perhaps, Justine, this is one for you. What is the difference between conflict of interest and confidentiality? Because I imagine they're quite often interlinked.
Absolutely, and I think that's a common question that we're asked actually by solicitors when they contact us, because they'll phrase their question as a conflict of interest, whereas really it's a conflict of duties, the duty of disclosure, which comes under confidentiality, confidential information, the duty to maintain that, and the duty to act in your client's best interest. So it's a conflict of duties rather than a conflict of interests.
Thank you. Right, we've got another question come in. It's quite a long one, but I'll do my best at reading it out. And thank you to Lucy. You win the prize for the one of the first questions coming in from a named participant. So Lucy's question is, it's about disclosure of video footage in criminal prosecutions. If advice is given over the phone or by a video call, clients are entitled to see the evidence against them if they'd been unrepresented. The prosecution would have sent the footage direct to our client. Our policy has been that we cannot show the footage to the client unless we're face-to-face with them, but that can limit the advice we can give in the meantime. Is there a way we could show our clients video footage remotely while remaining compliant? For instance, could we ask them to sign a document confirming they will not record the video or distribute it to anyone else? Would that be a reasonable step? You know, would that be acceptable to the SRA? So that, I suppose, a question about what you can share and risks around sort of confidentiality. So perhaps Sarah or Justine, is that one you could perhaps come in on?
Okay, I think the first step to take is to check with the CPS and what their obligations are when they release that video, because the difficulty is it's whether or not then the client signing the disclaimer will be sufficient to protect the solicitor, because even if the client does sign that, there is still a risk to them that the firm, that the client will disclose it to a third party, which they shouldn't do, where when they see the client in the office and can go through it, they have that safeguard in those situations. And it depends really on what the video is. There might be some sensitive information there from in respect to the victim. So I think to go back and check with the CPS in the first place. What do you think, Justine?
Yeah, I agree. I think that's your starting point. It's all about, as Ben alluded to, it's about risks, isn't it? And whether you can sufficiently safeguard yourself against the risk of disclosure to a third party where that's not allowed. And you have to evaluate that on an each and every case scenario, of course. And it is a matter for the solicitor's professional judgment at the time, if the CPS are happy that you do make the disclosure. So check first and then assess the risk and then make a decision. And as Sarah said previously, record everything as to why you came to that decision.
Thank you. And I think recording everything as to why you came to the decision is probably a caveat stroke asterisk to all our answers here, because, yeah, it's always good to have that down in writing. Right, we've had another question come in around consent around transactions, and there's a sort of couple of parts to this. One is about identifying the other party to a transaction. How can you identify them? And if we need to obtain the personal details of the other party from their solicitor, can a solicitor provide the other party's details, or do they need their client's consent? Do you have thoughts on that one? And I imagine this is the type of query that might also be coming up in our AML session tomorrow as well, because there's around identifying clients. But yeah, Justine or Sarah?
Okay, I'll start with that one. I think in terms of knowing who the parties are to a transaction, and that is something that's crucial for solicitors to know. If a solicitor has indicated that they're actually acting on behalf of a party, then you already know that they are acting as they are their solicitor, and you wouldn't therefore need their consent. So ordinarily, if you're on record, if you're acting, I don't see that there's any issue of confidentiality and disclosure in those circumstances to the other side. Do you agree, Sarah?
I agree with that. Apart from, taking it a bit further about the money laundering steps, and it depends what they mean by transaction. Are they talking about a conveyancing transaction? But you would expect the other solicitor who's in the regulated sector to have carried out their due diligence. Otherwise, they would be in breach of the regulations.
Yeah, of course.
Thank you. I'm not seeing any of the questions come in on confidentiality. So what I'll do is, if you have a confidentiality question, do still put it in, because actually, as we say, there's lots of links with conflicts of interest anyway. So, but Justine, I was going to come to you, and perhaps you could do a bit of a sort of an appetizer around conflicts of interest and what our rules are there, and then again we'll open up to questions. So get those questions in.
Okay, thanks, Ben. Okay, so again, conflict of interest is another common question that we're asked on our helpline or in writing where queries are raised with us, and by web chat, indeed. So it won't be a surprise to everybody today that we're talking about that. That was one of the top subject areas that you wanted us to talk about. And I suppose you might be wondering, well, when there's a clear rule stating you mustn't act when there's a conflict, why do you get all these queries? And I think it's because it needs the exercise of professional judgment to decide whether there's a conflict in the first place. Often there are quite complex legal situations that you have to consider. And that's why, whilst we can't give you a definite yes or no very often, if we're asked about, is there a conflict, we have to talk it through with the solicitor to help them arrive at a sensible conclusion about whether there is a conflict or not. Because, of course, the outcome is, if there's a conflict, you really shouldn't be acting. So let's think about the circumstances when conflict could arise. So there are two situations. The first one being the own interest conflict, and that's when your own interests conflict with those of the clients. That can arise in various circumstances. There's some helpful examples in our guidance note about that. For example, if you've got a private company that you've been asked to advise on a dispute about, where you're also a share owner in that company, or where you've made a mistake and given incorrect advice to the client, or wrong actions been taken on their behalf, you would have a personal interest in those circumstances and couldn't therefore advise the client on next steps, what to do to correct things, the client needing to go elsewhere to receive independent advice about it. And it's linked very closely to independence, obviously the SRA principles there, in terms of whether you can actually act. The second scenario where conflict can arise is where you're intending or wish to act for two clients. Could come up, for example, in criminal cases, acting for co-defendants, or when you're acting on two related matters. If there's a significant risk of a conflict or one actually exists, you wouldn't be able to act or must cease to act immediately, which can be quite detrimental to a client if you're partway through a matter. And that highlights the importance of timely and thorough conflict checks at the time that you actually start the retainer. And throughout the matter, because conflicts can arise at various stages, it doesn't also always become apparent at the start of the matter, and you need therefore to keep that in your mind as a retainer continues, to just think, well, is there a conflict here? Have I got any difficulty in making full disclosure to my clients or client in these circumstances? So what should your conflict check include? Many firms nowadays use IT systems to do this, and obviously that's a very good use of your time, you know, not rather than relying on individuals to do that. But just a top tip, perhaps you should include all of the names of your client former names, including companies, where companies perhaps have changed names and so on, to try and identify whether historically you've acted for the client in a matter where there might be some confidential information. Here's the link again to confidentiality with conflict, and that confidentiality needing to be protected. In those situations, it's highly unlikely that you will be able to act for both clients. And I say highly unlikely because there are some exceptions to that rule in relation to whether you can act for two parties. Basically, the exceptions are under 6.2 are that you can only act in circumstances where there's a clear common purpose. So the conflict is peripheral to the purpose. For example, setting up a business together, but you can't agree on the location of it. You can act in those circumstances and the clients decide outside of the retainer where they're going to actually set the business up, but you can arrange to, to do all the legal steps that you need to get the business up and running. The other situation is where the clients are both competing for the same objective. For example, two or more clients competing in an auction or in a tendering process. That's often the situation with tenders where it's large firms acting, only they have got that specific expertise where they may want to act for both of the clients. And those would be clients who have a certain amount of legal knowledge and experience and would understand and be able to provide informed consent to the firm acting for both parties. In other words, they know what information isn't going to be disclosed to them, and they're happy to take that risk because they have the benefit of the expert legal advice. The other condition, other than informed consent, would be benefiting the client, the risks outweighing the benefit outweighs the risk to the client. So such as having expert legal advice, as I said, a particular firm that they want to use. And you would have to have different fee earners acting, effective information barriers in place. And that's why I say, or use the example, that large firms may be able to act in these circumstances. You can't really imagine a very small firm where you haven't got that physical separation of offices and staff, and that includes the paralegal staff, the secretarial staff who may be typing up on notes, having access to the files. You would have to have that physical separation right the way through the firm from the fee earners down. So in most cases, if there is a conflict between two clients, it's better for the clients if you decline to act at the beginning, at the outset of the matter, because it's much more disruptive to them and causes complaints and dissatisfaction if you started to act and you have to cease to act immediately. Can't explain exactly why, because of your duty of confidentiality, of course, can have a significant impact on the client, the court, third parties, the other side. So all round, our best advice is that you should really not start to act in the first place. It could also have implications for costs, because of course all the work that you've done in preparation, when you didn't identify that conflict, may have to be foregone. You might decide from a practical point of view that you won't charge the client because they've got to then go elsewhere and have all that work repeated, and it's probably not going to be appropriate for you to decide to bill in those circumstances. So in summary, I suppose conflict of interest is very complex, but it's a common situation. As a compliance officer in particular, you'd need to ensure that there are effective systems in place to identify those conflicts, and a process and appropriate training for all staff so that it can be identified at the start of the retainer and also at appropriate stages as the retainer progresses. If a conflict of interest is identified, you then review the information and agree next steps to ensure that there's communication with the client and with appropriate individuals within the firm, that information is disclosed to appropriate people so that action can be taken. I was thinking there about the cost situation. And keeping a record, as we've said all the way through, that's very important to demonstrate your compliance with regulatory obligations and have this available for you to address any issues that might arise in the future. Okay.
Thank you very much, Justine. And actually, Keisha, I wanted to bring you in here because about a fifth of the sort of practicing solicitors we regulate actually work in-house. Is conflict of interest, are the issues the same there, or is there something particular that audience needs to bear in mind?
So the obligations under the Code, Ben, are going to be the same in terms of conflicts of interest, but the context in which in-house solicitors work will be different. So Justine has talked about the considerations within a private practice context. Within an in-house context, the potential is for you to already have existing relationships with clients, and where you identify that there's a potential conflict, you will then have to decide how you manage that. And obviously it will be fact specific, but sort of two important things that I would point out really are the importance of speaking to those seeking to instruct you to understand what those instructions are so you can properly assess whether there's a conflict, and then also to seek advice from a line manager or seek direction from a relevant colleague to help you decide how to address that situation. And again, the buzzword of the session so far, record your decision making.
Thank you. Was that a buzzword or a buzz sentence? But either way, I think we get the point, Keisha, and it's worth repeating. So thank you. I can see we're getting a few more questions in, and I want to be good on my promise that I said you can still send in questions about confidentiality. So before we move on to some of the questions we've got about conflicts, we did have a question about confidentiality, which is, if I receive a request for information from the police, should we contact the client first or ask the police to produce a court order? Is this a confidentiality issue or a disclosure with the risk of tipping off?
Okay, I think I can answer that. Tipping off is a very specific offence in the money laundering regulations, and it will be dependent upon what the police are asking you. And I think we always say the safest thing is for the police to go away and get a court order, and then it will protect the solicitor before they disclose any client's confidential information. Okay, that's excellent. So let's move on to some conflict of interest related questions. And thank you to Gull for sending in this question. And they've asked, in family proceedings, when representing, say, a wife and a husband, and they come in to instruct me as well, am I able to tell the husband I am already acting for the wife?
Well, of course, if you're on record and acting for the wife, then yes, you would need to disclose that to the husband, because the point of being instructed is that the other party deals with you rather than the wife directly, and that's the point of having a solicitor instructed. So absolutely, in those circumstances, your disclosure is just, yes, I'm acting, and at that stage you're not disclosing any confidential information. Obviously, as the matter continues, you're getting consent and liaising with your client about what disclosure is made in the proceedings. So
let's carry on then on the husband and wife theme. Is there a strict criteria for conflicts? For example, two clients bought a house 5 years ago, but they're now divorcing. Could we act for one of those parties?
Okay. The answer is yes, there's nothing prohibiting the firm acting for one of those parties because the matter is closed and any conflict would have arisen at that time and confidentiality would have been shared between the two parties at the time of the original retainer. So that's not a problem in those circumstances.
Okie doke. And can I act for a client who I have a relationship with, such as a member of my family? So your son or daughter comes to you and says, "Can you act for me on this transaction?" What should a solicitor do in that instance?
In most cases, you need to consider whether you can act independently for the client in those circumstances. It depends what the matter is. So, for example, if it's something where you're likely or there's a possibility you could be asked to be a witness in the matter, then it's probably not advisable to start acting because, of course, that would mean that you can't then put yourself forward to act as a witness on either side. And family situations, it can be quite difficult because you're very close to the matter. However, it's not a complete no-no. It depends on the retainer, and you'd have to assess that at the start of the matter to decide whether it's appropriate or not. The question being, think about your principles. Can I act with independence in the best interests of this client? Is it appropriate in those circumstances for me to act?
Okay. And just a reminder, thank you for sending the questions in. Keep them coming. There's a few that have come in that are incredibly sort of detailed and case specific. We will try and, if we don't get to those questions, and sometimes we're a bit limited in when there's a lot of detail there, how much we can go into those, you can pick those up with our ethics helpline colleagues separately outside this, but we will try and pick up the themes within those. So we have a question here. What about situations where both clients sign a conflict of interest waiver? How far can we rely on this document since both parties willingly agree to carry the risk?
Okay, I'll start with that, but feel free, Sarah, to chip in. Okay, basically a conflict can't be cured by a client agreeing not to have information disclosed to them in most circumstances. It's not in their interest to do so. So we would say you can't really rely on a waiver to cure a conflict. However, there is the issue about confidential information and those limited circumstances that I talked about previously or earlier on that outline where you can act with that in those circumstances where there are those three exceptions which allow you to for certain matters, for clients who are knowledgeable about the law, about the sort of legal matter and what disclosure is not going to be made to them. So in most circumstances, it's not going to be appropriate to say to a client, can I act where there's a conflict and get any sort of waiver? They're waiving their rights to disclosure of information and you acting in their best interests, and that's really probably not appropriate. Would you agree, Sarah?
I agree on that, and I think the two limited circumstances are set out in the rules about substantially common interest, which Justine covered earlier on.
Thank you. We've got a question here from Loretta that has come in. Thank you, Loretta, around conveyancing. Would a conflict arise if we are acting in a purchase transaction but realise the gifter is already a client on another matter, say a will or another conveyancing transaction? I'm just
sorry, Ben.
Yeah, so I'm
not
getting to the nub of what that question is. Shall we have a guess? What? Because I don't know whether there's a typo in there.
Oh yeah. Purchase. Can you just bear with us while we have a quick.
Can I,
Yeah.
Loretta, could I ask you just to resubmit that question again, and we'll come back to it, and we'll just because I don't know whether there's a missing word around the gift element of it. Let's go to another question, and this is obviously maybe a burning question for people on this call, may not be. I'm not a solicitor, so it's not a burning question for me. But can I have an affair with a client? That is a query we have had through the Ethics helpline. Or, do I need to stop acting for a client if I get into a relationship with them?
I can take that one. The rules don't prohibit a relationship with the client, but you've got to remember there may be an own interest conflict, and it depends on the circumstances. And I think it's got to go back to the principles. So it's not just the rules, it's the principles. Can you act with independence, and can you act in the best interests of the client? And I think that's where you would have to consider that. I think we wouldn't say it's an outright no, as Justine has said previously, but I think it would be fraught with risks.
I think that highlights why conflict's quite a difficult subject area for us and for solicitors. The example I always think about is where you're asked to act in relation to a family matter, and the fact that you are a partner of the client, perhaps you're in a relationship, perhaps you're thinking about cohabiting, is going to be very relevant to the retainer. And that's why you said it depends on what the retainer is, you decide that at the outset. So it depends. If it's something completely unrelated to you and the fact that you have a relationship, it may be appropriate. Yeah, so it depends.
And I suppose one of the challenges around conflict of interest, and why perhaps erring on the side of caution is often the right way to go, is you're not only looking at what the issue around potential conflict of interest is at this moment in time, it's also what things may happen in the future that then facts change, which then mean a conflict of interest. So you can't predict the future, but you are trying to think of what are the possibilities where something could happen, and how likely is that? Is that right?
It is. Sorry.
Absolutely, and I think that's where solicitors' expertise and the benefit of their experience comes in, that they have got that ability to see the possible situations where this is likely to arise. And the rule does talk about a conflict or a significant risk of one arising, and that's really the issue that you're alluding to there, and that we would talk to solicitors and help them seek to identify where there is that risk that can arise in the future, and where it's much better for you to decide it's not appropriate for me to start acting because there's a significant risk that I'm going to have to cease to acting at some point down the line.
Thank you. And then another question. I mean, I suppose my instinctive view in life is if I make a mistake, I try and, resolve it and sort it out. But do I need to stop acting for a client if I've made a mistake? Am I, inevitably conflicted then? Or could it be in the client's interest for me to proceed with the matter?
Questions? Sorry, could you repeat that, Ben? Sorry, I missed that.
So it's if you've made a mistake.
Yeah.
Does that inevitably mean you're conflicted and you just have to stop acting and say, go and get legal advice from elsewhere because I'm conflicted? Or could it be, obviously, that the client may say, well, actually, that's not in my interest because, you've left me high and dry. So could it be in the client's interest in some cases to proceed with the matter?
Okay, so we get this quite often on the helpline, don't we, Sarah? And I think it depends. You have to assess what steps you'd need to take in relation to the matter now. Is it something that you can easily do to put the matter right, and then reassess the situation to see if there is an ongoing conflict, own interest conflict, or is that apparent? For example, if you're late filing something with the court and you can try to seek to get that matter continued, then you will know whether or not there's a continuing conflict or not, because if the court agrees, obviously that resolves that issue for you there. The situation where there is an ongoing conflict, the client does need to go away to get independent advice, because of course you can't provide that independent advice. But having done that, it might be that the independent solicitor says to the client rather, that the best thing is that you go back to your solicitor and they do X or Y. So it's not, you can't continue acting. In those circumstances, having had that independent advice, if the client then wants to come back to you and you feel able to continue acting to take the steps that are necessary, you may be able to do so. Do you have anything else to add there, Sarah?
Yes, I was just going to add to that. We've got updated guidance on our website, Putting Matters Right Where Things Go Wrong, and that's hyperlinked from the conflict of interest guidance. And that actually demonstrates what Justine's just reflected. In the fact is, it depends on the circumstances. It depends on how big an issue it is to the client and whether or not it can be rectified. It's very a small one. And that one that Justine gave about limitation date, of course, you won't know that the fact until you've had that hearing that you've failed and you've got a potential claim until the court has decided whether or not they're going to allow you relief for missing that date.
And presumably, how would because a client may in those instances want to make a negligence claim on the firm's insurance, you know, if there's a mistake where they've, you know, suffered losses because of it. In that type of instance, would that be one where you would likely be conflicted, or does it again depend?
That's where the solicitor giving the independent advice outside of your firm would assess that. Is it better for this person in this situation to take the step of bringing a claim in negligence against the solicitor, or is it better that they proceed with that solicitor doing X or Y, or another solicitor outside of the matter? So it's for that person to weigh up the risks and the benefits of the client to all of the options and to decide and advise that person in their interests going forward. So if they decide that it's better for them to continue with the previous solicitor, then obviously that's the independent advice. It's up to the client to decide whether they want to continue or not and to continue to instruct you.
Okay, thank you. Really interesting. We had another interesting question here, which is about duties as sort of a lawyer, but also as a trustee. Now, if a lawyer is a trustee, but also providing legal advice to the organisation where they're a trustee, can the lawyer accept monies into their personal account as in their role as a trustee, or is there a conflict between being the lawyer? And obviously, I think our rules are very clear in your role as a lawyer that you can't be acting as a bank, and you shouldn't be receiving money into personal account. So, is that a scenario you've come across before? And yeah, what would be the answer there?
It is a scenario that we've come across before. It really relates to the accounts rules, I think. Would you agree?
I think
3.3.
so, yes.
And whether you're using your client account as a banking facility. And these are difficult queries that we grapple with and discuss at the team usually. So it's not something that's straightforward to answer. And I don't think that, I mean, obviously we can speak to the person afterwards if they want to phone our helpline, but I think we need a lot more detail behind the circumstances in which this has arisen to be able to give a full answer on that.
And in a perfect sort of seamless segue, and I can't claim we planned it like this, we do have the account rules session at 11:30 after this. So actually, if the person who asked that question wants to resubmit that question for that, that you may be able to get an answer through there. But as I say, there might be quite a bit of, you might get a similar answer that it's quite case specific and detail specific. So again, please do follow up with our ethics helpline colleagues. You may even be lucky enough to get Sarah and Justine again, depending if you're on the lines this afternoon. So we've had a more general question here, but I think it's a good one, which is what's your advice for ensuring colleagues, I presume that's colleagues within a law firm, don't see compliance as tick boxy and take it seriously? What recourse should there be if lawyers don't read compliance-based emails, for example?
I think this is about having systems in place in your firm to ensure compliance, and it's not one size fits all. Of course, you've got to decide what's appropriate for your staff and for the size of your firm as to what will work effectively. So we don't have anything specific in terms of you must do X or Y. It is a case of deciding what's appropriate. There are lots and lots of different ways of ensuring that that staff don't see compliance as tick boxy. We would definitely not say that compliance is a tick box exercise, and I suppose they're alluding there perhaps to conflicts and conflict checks, you need the human element. And whilst I said lots of firms now use sort of AI or use systems to check compliance, you can't get away from the expertise and the knowledge that a person has, which is why really the system should encompass referrals to perhaps the compliance officer where there is a question or any doubt, so that they can assess the matter with their legal hat on and their legal knowledge to decide whether it's an issue or not. I don't think there's any replacement for that. Have you got any thoughts, Sarah?
I think it comes down to the policies and procedures of the firm, supervision and training, and to ensure that new staff are trained appropriately and that this information is shared throughout the organisation, because it's not just important for fee earners. Sometimes in smaller firms, they have admin staff dealing with, as Justine said, about conflicts of interest checks, and it's ensuring they understand what the implications are if they don't do it appropriately and these safeguards aren't met.
And I suppose there's a more general point as well, a reminder of the history here. We used to have a 1,000-page rule book. We went to a 600-page rule book, and now obviously we've got a shorter rule book where we're down to 130 odd pages. And part of the drive there was to move away from a sort of either a tick boxy or there is a rule for every scenario situation, because actually you're always chasing your tail. There is always an exception or another example or a different case. And so that's where, to go back to our buzz phrase, the first starting point shouldn't be on any compliance is looking at the principles and working out, using your own professional judgment on the case specific facts, how would those principles likely apply in that scenario, and going back to the buzz phrase, making a record of the judgment you're making around that. So that's what we're very much encouraging and want solicitors to do, which is why there's not always a sort of tick box or checklist answer in every single scenario. But it's something we grapple with as well, about how we make sure solicitors do that. And I suppose I'm preaching to the converted because you're on this call, but that is something we're going to be working on from our side, about how we can engage solicitors across the sort of 160,000 so who are practicing, to make sure they understand their obligations. Right, we've got a couple of final questions on conflicts, and then we should have time to just do sort of referrals and reporting obligations. So we've got one question here: as someone who's an in-house solicitor, can I pass work to my spouse who works at a law firm? Or again, would there be a conflict of interest there? Or
I don't see why not. Obviously, if you think that your spouse has the necessary competence to deal with a legal matter, then and they're an appropriate person and the firm can provide a service to the client, then I don't see that there's automatically any conflict there just because you forwarded that on to your spouse or suggested that person to act in the matter. It's a judgment decision for you as when you're making any recommendation to a third party. Are they appropriate? Do they have competence? Is this referral in the client's interests?
I suppose go. No, you go ahead, Keisha.
Sorry, Ben. I was going to say, I would just, obviously the decision sits with the client, so I think it's really important that the client is aware that this individual that you're suggesting is your spouse. So just to be transparent with your client is all I'd add.
And I'd probably suggest, and this isn't even a particular solicitor point of view, but a sort of propriety point of view, I've never been in a scenario where I've been passing work to my spouse, but I have on occasion been asked for a recommendation of somebody to do work, and it's been somebody who I both know in a professional and almost personal capacity. And in those scenarios, I would always get an independent person within the organisation to look at their skills and whether they were the right person for the job, to avoid any sense that, you know, sort of from a sort of gift and bribery perspective, that I might be passing on work to acquaintances or friends or family. So I think I probably would suggest that it'd be worth, if you're doing that, not just to be making that decision on your own in isolation. So final question here. I have a client who wants me to continue acting but wants another solicitor in another firm to do the advocacy. Can I agree to this?
I think I can answer that. It's not really conflict or confidentiality. I think we're talking about unbundling services. Do you agree, Justine? Where you do the work, isn't there a risk there? You know, what are the circumstances?
Yeah, why do they need to go to another solicitor?
Yeah.
So I'm not, the question is, wants me to continue acting, but wants another solicitor to do advocacy. Oh, okay. So you're acting in the matter, and somebody else in the firm just does the advocacy, which perhaps is no different to instructing counsel to do the advocacy. So there's no reason why that can't be done in-house. Again, down to competence, and if they're an appropriate person to suggest to do the advocacy. So I don't think that there's any difficulty in that sort of arrangement within firms where they have an in-house person doing advocacy at court.
It depends on the circumstances, but it's one for them to think about, because what control do they have over it? And the person that's doing the advocacy, who's not maybe in the firm, then it's, will they be happy just doing the advocacy? Who's going on the court record, etc. So I think it's a bit of a difficult one to answer in sort of like a snapshot about what's going on.
But yeah, I think you've neatly set out what the key considerations might be, but again, that might be one if you want to follow up with the case specific detail with our ethics helpline. Oh, I see. Just before we move on to our final topic, Loretta has come back. Thank you, Loretta. So let me read out this scenario again. So if we're acting for a client in a purchase and they have a parent giftor, but we already act for that parent in another matter, say that we're acting for them already in an unrelated matter, such as a will or sales transaction, can we still act for the client's purchasing, as we may only realise their parent is the giftor or during the transaction?
Okay, I think I can take this, Justine. If I don't think it's a direct conflict. I think the problem they're probably concerned about is confidentiality, because what if on one matter they hold confidential information that would be relevant to the other matter and the people's decision making about how they proceed? So it would be something for the fee earners to sit down and think about. Do we hold confidential information? Is it relevant to the purchase, or is it relevant to the making of the will? On the face of it, it may not be relevant. There may be no confidential information, and that's something that they'd have to look at the file and think about in those circumstances. Would you agree, Justine?
Yeah, absolutely. I think it's one of those that spans the two areas. It's not really to do with conflicts of interest, as is rather more protecting confidential information and assessing whether there's any risk that you may need to disclose the information in the other matter where you aren't able to do so.
Thank you. We're going to move on to our last topic because we've got 13 minutes left, and there is a fire drill here at 11, and this could turn into the worst webinar ever if the fire alarm starts going off during it. So I'm going to move over to Keisha. Thank you to those who asked questions. I realise we've had loads of questions, so there's some that may not have got answers yet. Do follow up with our ethics colleagues if your question hasn't been answered, but I think we've got through a good amount there. So Keisha, do you just want to give a bit of an intro to sort of what our expectations are around obligations around reporting, and then if we can pick up any final questions on that, that would be great.
Yeah, happy to do so. So our reporting and notification obligations are set out in our code of conduct. And also there's a really helpful document that we publish on our website called our enforcement strategy, which provides more information about the approach you should take, the issues that you consider, the types of cases that we take more seriously here at the SRA, so are likely to end up in some kind of sanction. There's also helpful guidance on our website that you can access if you need some further information in terms of understanding what to report. What I want to talk about today is not about the notifications, so the matters that you must report to us, but those issues that are more complex and where you're going to have to exercise your own judgment in terms of understanding whether to make the report. The first point, I suppose, to cover off is why report. So I've mentioned the obligations in the code, but also if you report issues of misconduct to us, then we as the SRA can take action, and we can take that action more promptly if issues are raised early on. So we say in our enforcement guidance, report promptly. What does that mean? So it may be that you're partway through an investigation and you don't have all the facts yet, I would still suggest in those situations that you make contact with us and we can talk to you on a confidential basis, understand where you are in your investigation, what your concerns are, and potentially give you some advice about how to take that forward, whether it's worth just, making that formal notification report to us, and we can open a file. It doesn't mean that necessarily that we will start our investigation proper. We may just hold that information and wait for you to come back to us. We do have powers to impose interim orders, so I think that's helpful to understand, because that may limit or restrict how an individual works. And so the earlier we get that information, the earlier we can take action. It's also helpful for us to have information so we can understand trends and risks in the sector. We have various methods of seeking that information ourselves, but obviously as solicitors you hold just a huge amount of information that could be helpful for us to understand. So again, sort of that for us to understand patterns and trends is also really important. So what to report to us? I think sort of the date of the incident, the time span of the issues arising, the date your organisation or you became aware of that, how you became aware of the potential misconduct, who's involved, what action you as an organisation or an individual might have taken already, whether what further steps you're planning to take. Those are all helpful questions for you to answer and will help us get a better sense of the misconduct that you're reporting. So as I mentioned, some of these issues require you to consider and apply your judgment. We as the SRA will take formal action in relation to the most serious cases of misconduct, and that really that includes issues such as abuse of trust, taking unfair advantage of clients, misuse of client money, sexual misconduct or violence, dishonesty, discrimination, harassment, and also criminal behaviour. We also take breaches of information security seriously, and the seriousness of a breach will be dependent on the intention behind it. So again, when you are considering reporting to us, think about how something happened, why something happened, to the best of your ability. Obviously, you might not have all the information to reach those conclusions. Other factors, Ben, that I wanted to pick up on were potential vulnerability of the victim, or and also witnesses who may be involved in reporting, in supporting a report to us, the role, experience and seniority of the individual involved. That will have an impact on their understanding of what's required and expected of them, as well as approaches to remediation. And the final sort of key issue, I suppose, would be, is this something where there's a pattern of behaviour? So we're really aware that mistakes happen and issues can be a one-off, but where you're seeing a pattern of behaviour, that then is something that triggers for us a level of seriousness in the investigation.
Thank you, Keisha. I suppose one quick question on this is, what do you need to complete an internal investigation so you've got sort of fully under the bonnet and the facts before reporting to us?
I think it's fact specific. I would say that you want to be in a position where you can comfortably reach a view that there is a matter of concern that you want to report to us. You may not know the full extent of that, and you may not have gathered all your evidence, but I think if your internal alarms are going off and you think that this is something serious and this is something that I should report, then, pick up the phone, speak to colleagues in professional ethics. They will support you if you need to speak to somebody else within the investigation team to get more, to have a discussion. But yeah, I wouldn't I wouldn't wait necessarily until you have a complete investigation. And I think also, Ben, just a chance to cross-reference our guidance. We've recently published some guidance for in-house solicitors, and one of the pieces that we have published is about internal investigations. And I think there are some sort of in principle sort of issues that anyone can consider. You don't need to be a solicitor, an in-house solicitor. You can be from private practice. And there are sort of factors that you would want to consider as part of your internal investigation.
Thank you. Well, talking of internal alarms, as you say, I'm worried about external alarms going off in 5 minutes. So let's just do some quick fire mop-up questions that I can see that are outstanding. We've got a question from Paul. Hopefully this is quite a straightforward one. On a conveyance file, we have a residual balance of £50. The client says they do not want it back. Give it to charity, they say. Do we risk breaching account rule 3.3 by paying the £50 to charity?
I would say not, because it's prescribed in the rules that you can do this. So again, accounts rules, you might want to take this up with at the next session as well. But basically, we deal in ethics with applications to withdraw money from your bank account, residual balances. But of course, if it's under £500, then you can make that decision yourself. Making the payment to a charity is not itself disclosing anything, so I'm not sure why there is concern here about about disclosing any confidential information. Anyway, you're just paying the money to them because the residual balance, because you can't actually find the person to whom it belongs to repay it. Anything to add there on residual balances, Sarah? Well, we covered everything.
No, I think that's pretty much covered. And under Rule 5.1, yeah, it covers this in the accounts rules.
And if you're really interested in residual balances, in the interest of cross promotion, our next session at 11:30 is on account rules queries. But then also we've got a session at 1:30 on our consumer protection, our client money consultation. But one of the things we're looking at is whether we need to tighten up some rules around residual balances, because we do have some concerns that some firms are holding on to residual balances for a long period of time. So do join those sessions if you want to. I've got one final question. Perhaps I'll come to you on, Keisha. This is around sanction checks. And this scenario, someone's done sanction checks and it reveals numerous entries under the same name. So there's at least one with no specific date of birth or passport number, and the sanction list says they're sanctioned for promoting terrorist activity. Is it impossible to tell whether the entry relates to their client or someone else? Does that mean that client can never act for an individual that shares the name with the sanctioned individual?
So we consider Ofsey's consolidated list to be a good baseline check. Where a sanctions check doesn't give you a clear answer, though, you should consider other characteristics of the client and decide for yourself whether or not they match up with the individual concerned. If you're still unsure, we would suggest you gather further evidence potentially from your client to enable you to make a determination.
Excellent. And a 30-second answer to this one, Sarah or Justine. Someone's asked around financial stability. What should I be doing and monitoring on a monthly basis in terms of making sure I'm meeting my obligations around financial stability?
I don't think there's anything specific. We've got guidance about, financial instability, but I think it's usually, can you pay your staff? Have you got enough, money coming in for your bills to cover all your overheads? And I think that's just normal, overheads and everything else for a firm or, a sole practitioner to consider, have we got enough to pay the bills, really?
Okay. That seems like a good note to consider a finish on, and we all want to make sure we've got enough money to pay the bills. Thank you, everyone, for joining us. Thank you for Sarah, Keisha and Justine for dealing with all those questions. This is recorded, so you can play it back if you want to see it. We'd love to hear what you think of this session. There's a feedback link below. That feedback is really useful for us understanding you know, what worked well, what can improve. I apologise that all of us seem to have been sitting in a black and white world, or at least me, Sarah, and Justine are, where all the room is black and white. I will convince you that there is some colour at the SRA, and Keisha is proving that. But there's some blue in your background. But I think it's been really good for you to join us. Keep on coming to the webinars, and I hope everyone has a good morning and afternoon. Thank you.